Indian Penal Code. Though this subject is of around, I hope, more than 550 sections now. You are not required to count because it is not material for you. You are not appearing in preliminary examination. Your examination is mains examination. So there are more than 550 sections scattered in 23 original chapters. And then there are additions, subtractions. But you should not worry at all, because hardly out of 550 sections, if you ask me about your exam, it may be 50 sections which are relevant. How I'll let you know just now. Just make yourself comfortable that this is very small subject, number one. Very small subject. And in these 50 sections, I hope there are hardly 25 questions, which are your exam questions. So the syllabus is 50 sections, 25 questions. It is so easy. Is this clear? मैंने आपको एक आइडिया बताया पहले. This is Indian Penal Code. Why it is called Indian Penal Code? Because it applies in India. Why it is penal? Because it is punishing law, and code is exhaustive enactment on any point. And it is subject of almost more than 550 sections. And out of those 550 sections, hardly 50 sections are relevant. It will apply mutatis mutandis to other exam also. Primarily, I am speaking for IS examination, but it will apply for judicial services as well. There will be certain additions there, so you should not worry about that. And hardly 25 questions. How 25 questions and how 50 questions, 50 sections, I'll just explain to you. Is this clear? Now, for example, if you have seen your syllabus carefully, just see your syllabus. I hope all of you are acquainted with syllabus. Whenever you read, you must have idea of syllabus first. So, if I see your syllabus in our book, Civil Services Examination, this is Law of Crimes. If you see paper 2, Law of Crimes, you find that the 13 topics there are related to IPC. 1 to 13. Can you see this? General principles, kind of punishment, preparation, attempt, exception, joint and constructive liability, abatement, conspiracy, offense against state, offense against public tranquility, human body, property, women, defamation. So these are 13 topics which is to be read. अब इसमें सवाल कैसे बनते हैं? बहुत आसान. जैसे देखो, पहला टॉपिक मैं तुम्हें बताता हूँ. लिखा है जनरल प्रिंसिपल्स ऑफ क्रिमिनल लाइबिलिटी. You have only one question in this topic, and the question can be formulated in different ways. You will have to learn the trick of, there will be many questions, but it will have one answer. बहुत सारे सवालों का एक जवाब होगा. जैसे मैं आपको उदाहरण देता हूं. You will be asked a question. Act and intent must concur to constitute a crime. What I said? Act and intent must concur to constitute a crime. भाई act and intent जब मिलेंगे तभी crime होगा. Is this clear? I formulate the same question in different language. Actus non facitrium nisi mens citria. Explain, examine, elucidate, discuss. This is the second question. I can formulate the third question also. There can be no criminal liability without criminal intention. The same question. अब आप इसको देखो, where the questions are written of criminal law in your book, page 88. Page 88. See the same question. What are the constituent elements of crime? Mens rea and actus reus. Discuss the importance of criminal law, 2005 question. Also explain the role of mens rea in statutory offences. Then question 6. Intention and act both must concur to constitute a crime. Then it's question 8. Discuss the importance of mens rea in criminal law. Explain also the role of mens rea in statutory offences. Refer also to relevant case law. Then question number 11. Substantiate the statement that presence of guilty mind is an essential prerequisite of liability under penal code. Question number 1. Whether the maxim actus non facit reum nisi mens rea in general and the common law doctrine of mens rea as an independent doctrine in particular are relevant in the interpretation of provision of Indian Penal Code. Same question. Examine the above in the light of juristic opinion and judicial pronouncement. So question number 1, question number 2, question number 3, question number 4, question number 6, question number 8, even question number 9, question number 10, question number 11. These have same answer. These have same answers. Is this clear? How many questions I spoke? Number 1, number 2, number 3, number 4, number 6, 5, number 8, that is 6, and number 9, that is 7th, number 11, that is 8th question. So 8 question has 1 answer. It will be answered similarly. If you have any doubt, you may raise it right now. Well, which question do you think that will have different? Now there may be variation of 5%, 10% here and there, but not beyond that. But that much you should understand. But the basic crux of answer remains same. We'll be explaining in all question that how crime is constituted. We'll be explaining the same maxim of actus non facit reum nisi mens rea. And this is what will happen in almost all topics of IPC. Now just for your conviction and confidence, let me take the most important topic and the most difficult topic. And I hope it doesn't need any explanation what is the most difficult in your eyes and most important too. And it will have most number of questions as well. And as I can see in my material, it has 33 questions. It has 33 questions. And this is culpable homicide and murder. And let me ask you, what will be question in culpable homicide and murder? I tell you, if you learn one question clearly, there are other questions which are subsidiary, supplementary, ancillary, auxiliary question. So what is the prime topic? Culpable homicide is genus, murder is species. All culpable homicides are not murders, but all murders are. Some culpable homicide becomes murder, some not. When culpable homicide will become murder? And even if we are asked a question, which is application-based question, on murder, you will have to answer the question on the basis of difference between culpable homicide and murder. And this is not what I am saying, this is what your Honorable Apex Court has done in many cases. You pick any case. I tell you one case which I have quoted in your material, State of Andhra Pradesh versus R. Punayya. So if you see this decision, They have quoted the decision of R versus Govinda. And they have verbatim written what Justice Melville said in that case. So they copied it. And they said the same thing while deciding a question on murder. So it is the necessary process which you are required to follow. And if there are any other question in this topic, it will be answered on the understanding of this difference, I tell you. Now obviously, if you read carefully the questions here given, I am talking of 299, 300. If there is any question on 304A or 304B, generally not so much. 304A though there can be some question, but 304B generally there is no question on 304B. I don't know why Civil Services Examination doesn't ask that question. See, question number 2, section 300 subsection 4 of IPC will be applicable in cases where knowledge of the offender as to the probability of death of a person approximates to practical certainty. Illustrate the above statement. Unless you understand difference between 299 and 300, you cannot write this question. And that is what I am talking about, certainty. We are talking of certainty in case of 300 in comparison to 299. Then there is a question, there is very thin but fine and subtle distinction between culpable, homicide and murder. This is question of 2017. The first question which I read was of 2018. Now it is 2017 question. The difference lies merely in the different degrees of probability of death. Discuss the statement and refer to decided cases. Then 2016, culpable homicide is not murder if it is committed without premeditation in a sudden fight and this is exception. Explain with the help of decided cases as to when culpable homicide under section 299 subsection 3 will become murder. A assaulted his wife by kicking her repeatedly on non-vital parts. Again, you are deciding the question of culpable homicide and murder. Question number 7 here, asked in 2014. So, what we are trying, now question number 10, culpable homicide is the genus and murder is species. And that all murders are culpable homicide but not vice versa. Discuss. So, I read so many questions and I see that these are the same questions. So, what I said just now, I said the syllabus of IPC is hardly of 25 questions and hardly of 50 sections. Now, I hope you are clear about this little bit, how it is 25 questions only. I'll tell you the topics, don't worry. I'll tell you the topics today itself, what are the questions to be read. But how it is 50 section only? Now, whenever I speak this, I remember I have spoken at several forums. People will generally not accept this. But this is the truth. And this is what, if an aspirant understands, IAS exam is cakewalk. Otherwise, it's a mountain walk. Walking on the hill. It is not like that. It's a very simple thing. But just you are required to understand the approach. You should have little bit experience for it. Little bit expertise, little bit skill. Now, how it is 50 sections? Let me give you some example. Suppose I have to study the topic of theft. Everybody knows theft is written from section 378 to section 382. Is this clear? Without amendment I am talking. There are many state amendments also. If you see Haryana, there are amendments. Snatching and this kind of things are there added in this theft, 379A, something like that. You will find there are amendments because IPC is concurrent list subject. So even a state can make a law on that point. So different states have made laws on those points. But generally it is 5 sections. How many sections are there? Out of these 5 sections, one section is for understanding and another 4 section is for punishment. It defines offense of theft. Only one section. This is 378. So, you are required to study 378 only. These are punishment sections. 379, 380, 381 and it does not require any effort in understanding, I tell you. No effort is required. 379, 3-year punishment. You can remember anything very easily. It is 3. So 3-year punishment. People say, how can I remember? I say you can remember anything if you want to remember. If you do not want to remember, you have many excuses. 380, theft in dwelling house. So obviously punishment will be more. And let me tell you, in IPC, generally punishment is 1 year, 2 year, 3 years, 7 years, 10 years, 14 years, life imprisonment. Generally, I said. अब पढ़ेंगे पूरी IPC आपको पता चल जाएगा. तो 3 year के बाद 7 year आता है. हमें याद नहीं करना होता कुछ भी. I have to understand. Theft by clerk or servant, again 7 years. And theft after having made preparation for death, hurt or wrongful extent. So this is very grave, 10 years. I am not required to remember these things for IS examination at least. I just want to know what is here, what is here, what is here, what is here. This is just clarification. These are additional information in 4 lines. So I will not count them as sections. No, not at all. What is section? And which section I have to read? Only 378. So out of 5 sections I have to read only. So is this first part clear to you? First part clear to you? Questions and sections. 25 questions and 50 sections. Clear? If you do not understand the approach, you will be putting a lot of efforts and you will be getting very little result. So try to understand the expectation of examiner and exam. And that is why I say generally to my students that you please try to understand exam and examiner. If I am asked about this examination taking IPC in reference, I will say I understand the exam. This IS exam you will find either there is traditional, classical questions or there are current questions. But as far as I think that generally the traditional questions have more space. You pick any year question. But obviously it is also important. So I will suggest you to prepare both. Like you should know what is current discussion in IPC. Are we discussing death penalty? If it is so, you should read it carefully because you will face a question. Are we discussing about this making attempt to suicide not punishable? If it is so, this will be a question. So wherever you find that there is discussion going on that particular topic, in that particular, now earlier there was question, discussion on this abolition of defamation as crime. So this can be a question. Plea bargaining is an important tool today to minimize the litigation, and litigation is one of the biggest issue in our judicial system. You have so many cases pending in court. So plea bargaining is very important, and that is why it reflects in IS topic, though it is a topic in CRPC. But we have been given a topic like that because that is important. So just and this you can understand by reading of newspaper. If you are in sync with what is happening in and around you, so you will be knowing what is going on. At least you should be aware of what is happening in our subject at least. And mutatis mutandis, that is with necessary modification, it will apply to all subjects of IAS examination because you are going to be planner. How can you become a good officer if you do not know what is happening around you, and how will you counter this problem? So you should know it, at least about your subject you should be thorough, so that I can have confidence while I appoint you that you will be a fit officer who can plan according to the situation. So you should know. Is this clear? Now, so traditional classical questions can be found in previous year question paper. So just see PYQ, and for that purpose I have already published for you this. How many years question? I have written also last 42 years question papers, and that too topic wise. So I have made your task very simple. So you read it carefully and don't take it lightly. This is not a book of now. कितने की बिकती है? कितने की बिकती है market में? 120, 110. So it is not 110 rupees book. It is my skill. It is my effort which I have learned during teaching of last 15, 16 years when I published it for the first time. I thought that this is what can help my students. So आपने कुछ नहीं करना है. You have to just pick up the question and you have to prepare accordingly. So this you will get there. मैं आपको एक एक चीज का तरीका बता रहा हूं. Mind you, and I have personally edited it. Last time also, there may be 1, 2 here and there, some mismatch, but generally you will not find that. Then current question. Now, in certain subjects you will find it more. Like I tell you, paper 1 is more dynamic, if you have realized this. Paper 2 is not so dynamic. Paper 1 is more dynamic in the sense that, see, paper 1, if you have realized this, there is in UPSC paper 1, paper 2. Paper 1 basically deals with constitution and international law, and it basically regulates the conduct of your state itself. The state and the state machinery is regulated by constitutional law, administrative law, international law. And you and me, we are more regulated by paper 2. IPC, contract. There is a contract here. If somebody is disturbing us, there is a tort there. So it is about our relationship. Are you getting the point? So paper 1 is more in nature of public law in that sense. And paper 2 is more in nature of private law in that sense. In that sense, I said public and private has many meanings. So paper 1 is more dynamic. Constitution, administrative law is more dynamic. Even to some extent international law. But international law that doesn't have, our question paper that doesn't have that much dynamism which is there in constitution, I tell you. But in paper 2 it is not so. Sales of goods, partnership, contract, IPC, you read these bare acts carefully. You prepare basic points. You will get very good marks. I tell you the fundamental difference between preparation of paper 1 and paper 2. Paper 1 is more in nature of current relevance. The questions are more of current context. You are required to be more abreast with what is happening here and there. But in paper 2, you will find more traditional questions. Of course, if there is some discussion going on about abolition of defamation as a crime, and that may reflect in your question. Is this clear? Is this all right? Now let us move further. So you understand the nature of question. So I have covered till this point 3 things. Again I am repeating for your convenience. Let's see, any subject in IAS examination has certain number of questions. Try to pick them. It is in IPC, it is in other subjects also. Contract or constitution, any subject for that matter. And the questions will be basically from 2 areas. Hardly 25 questions is on higher side, I must tell you. Contract, hardly 15 questions. Tort, 15 questions. IPC, I have written 25 deliberately. If you see carefully, it may come down to 15 questions. Very important 15 questions. I'll tell you 15 important questions in IPC. Constitution, maybe 70, 80 questions. International law, maybe 50, 60 questions. Now similarly, partnership, 6 to 8 questions. Sales of goods, 6 to 8 questions. Agency, similarly 6 to 8 questions. So small papers on rough has 6 to 8 questions. And middle or medium subject has 20 questions around, and bigger subject may have 50 to 60 questions. How will you do it? One of my friends was asking a question, answer writing is a difficult thing. You just prepare 2 pages notes very clearly. And you write the basic idea there. I'll get it done for IPC, don't worry. I have my answers also with me. I hope I have brought it for you. I left it outside the class, but I have the answers. I have written answers in 200 words or 150 words. I'll just show you in the other session, don't worry. So I have written the answers. And very basic answer. Anybody can write that. So your preparation is basically 250 question preparation of entire paper 1, paper 2. And do question wise preparation. Never do text wise preparation. If you are supposed to read IPC, you have bought a book of IPC and started reading. And then you will keep on reading. You will become Macaulay but not an IAS officer. Exam has particular technique. Let us learn that. Now, I'll just explain to you a little further when I take up the first topic of IPC. But before I go into the topic of IPC, I hope about exam you are clear. You will prepare questions of every subject and you will prepare 2 to 3 pages notes of every question. And if you understand, you can adjust that 2-3 pages notes into 1 page, and if required, you can write even more. That art you will learn. You don't worry about that. I'll tell you that, how to do it. Like one student asked me, if I remember correctly, how will I write difference between culpable, homicide and murder in 20 words? So I was also a little bit surprised. How can I answer it in 20 words? Justice Melville could not do it. Justice Sarkaria could not do it. How Professor Ranjan can do it? I am Vice Chancellor also of university, if you don't know. So how can I do it? Now I have to work upon this. I answered it then and there because I was asked this question in question answer session in my class. So I had to answer that question. So I said, in culpable homicide and murder, actus reus is same. Mens rea is different, and that is why they are different. Every crime consists of 2 elements, actus reus, mens rea. You have asked me in 20 words. How can I explain mens rea in 20 words? Tell me. How can I tell you the whole story of culpable homicide and murder in 20 words? Because I'll have to speak a lot. If you ask me the difference in 20 words, I'll explain like that. Now, another person came and he asked me another question. So you just explain me 299b and 300 secondly in 50 words. I said, this is also a difficult proposition. But let me try. Because if you have asked a question, I'll have to answer. So I said, have you heard the story of Mahabharata? He said, yes sir, I have heard. So have you heard the story of Duryodhana? How he was killed? He said, yes sir, I have heard. I said, if you have heard this, you know about 300 secondly. Lord Macaulay has taken inspiration from there. If the death is caused with the knowledge of particular ailment, of particular victim, the person there, the Krishna, they knew about it. Where I have to hit Duryodhana. So is it not 300 secondly? I have no other option to explain this in 50 words. And I said, this is the best example which I can give you. Can there be better example than this? So this is what is the skill which we are required to develop. If you take my word seriously, if you take my suggestion seriously, which I have given you just now, I hope you cannot look back. You will excel in your exam, without doubt. I'll tell you how to write answers. I'll dictate you answer. I'll give you model answers. Don't worry for that. I have many model answers. I'll give you those answers. I'll show you just now. But let me begin with this IPC, very interesting penal code. Indian Penal Code. The subject of, according to you, 550 sections and according to me, of 50 sections. This is what is perspective. When you ask Arjuna what he can see, so he says, I can see the eye of the fish. And if you ask somebody else, he will say, I can see the entire world. This is what is perspective. I see that IPC is very small subject. Very small. It is so small that it can be covered within a week. Though I am not going to do it. I'll devote time with you, don't worry. I'll take little bit time. I'll make you happy and then only I'll leave the class. If you do not understand any idea, you let me know, I'll make you understand. That is not the idea here, but just to give you confidence, I told you that this is hardly 50 questions, or 25 questions and 50 sections. I have explained it a little bit. I'll explain it a little further. Now, let us understand what is IPC all about. IPC is Indian Penal Code. So, obviously, it penalizes the act or omissions. It describes the offence. What IPC does? IPC first of all describes general principles of criminal law. Obviously, I'll tell you first general principles of criminal law and then I'll explain the offence and then I'll describe the punishment. Then what it does? It mentions different offences and its punishment. This is what is IPC. So basically principles, offences, punishment. That's all. I don't see many things written here. Now if you see general principles of criminal law, I think you can easily see chapter 1 to chapter 5a and chapter 23. These are all general. It will apply to all offences. And then offences, chapter 6 onwards to chapter 22. So almost this many chapters of offenses and their punishments, and these many chapters of general principles. Is this clear? But irony is this, that we do not understand. And when you do not understand, then you cannot score. And when you do not score, you will never blame yourself, as Buddha correctly said. That when you point one finger towards other, 4 fingers are towards you. So you do not see these 4 fingers. You see this one only. Subject is not good. It is so bulky. Who says this? This is all opinion made by a person who has never read the subject or who has never understood the subject. These all opinion makers are wrong, because their opinion is based on non-understanding of the subject. My opinion is based on understanding of the subject. You see, is it general principles of criminal liability or not? Yes. How many chapters are there? I have just written chapter 1 to 5a and chapter 23. Now, there will be different questions coming in your mind. As your exam is mains exam, so you do not need to go into nitty-gritties of the subject, but just for your kind information. Even these chapters which are written from 6 to 22, they are arranged in a logical manner. Without wasting much of your time, I must tell you, this IPC has been formulated or formed for what purpose? To preserve peace in society, to maintain law and order in society, to give protection to your body, property, reputation. See, you know about this. If you understand a little bit how law has come into existence. The state has given us guarantee. I am not going into history of the subject, but I just tell you, the state has given you a guarantee that if you are my subject, I give you guarantee that I will protect your interest. Nobody can interfere with your interest, either bodily or property. Because see, if somebody comes and interferes with the interest of your body, you will feel bad. If somebody takes your property without your consent, you will feel bad. And this will give rise to violent behaviors. This will give rise to law and order problem. This will disturb public peace. This will create public disorder. So we have created different offenses to protect your property, protect your body. You see carefully. If you start from chapter 6, first of all, we are protecting a state. If a state is not there, how can we survive? And if you want to protect a state, protect those people who protect your state. And who are they? Army, Navy, Air Force. So there is second chapter, offense against Army, Navy, Air Force. But Army, Navy, Air Force generally protects you from external aggression. You need internal arrangement to be perfect. So how will you do it? So we created offense of public tranquility. And who will do it for you? Who will do it for you? Tell me. Public servants. So I have created offense for their protection as well. Apart from this, we have variety of interest. We have our own individual interest, as I said, body, chapter 16 of IPC. Property, chapter 17 of IPC. Marital relation, chapter 20 of IPC. Reputation, chapter 21 in IPC. I think so. So see, these different chapters of IPC is protecting different interests which you have. Is this clear? I am not going into detailed explanation of the subject, which is not called for this class at least. Otherwise, I could have spoken on rights, duty, interest. We have bodily interest. We have interest in property. The whole jurisprudence is filled with such discussions. Why do you protect property? Why do you protect possession? Why do you talk about ownership in jurisprudence? This is the reason we want peace. That is what is Rousseau, Locke, Kant, all said that. But we are not discussing jurisprudence here. We are not going to deviate. We are preparing for our exam. So we'll concentrate on 50 sections, 25 questions. But I just told you that see, this chapter 6 to 22 is nothing but protection of different interests which you have. You tell me, do you not have protection? Do you not have interest in protection of your religious feelings? You have. You have. You have. You have interest in protection of your religious feeling. So if there is anyone who is hurting my religious feeling, that is also an offense. Do you not have interest in preservation of peace in your society? You are just complaining that the nearby restaurant wala, they are producing much sound and we are disturbed. So you want preservation of peace and order. So you have created that offense. You have created offense of nuisance. Is this clear? So how this chapter is organized, you understand? And I tell you, if you have time, just think of some time. Not right now. Right now you concentrate on 25 questions and 50 sections. But if you have time, just think of. See, my body. You can see me. And you can see yourself in mirror. So you see yourself as well. You find similar arrangement or not? Tell me. So every subject, every topic, every section, and even sections, subsections, there is an arrangement. If you can pick this, well and good. If you cannot pick this, it is not well and good. I remember section 299 has 3 parts, 3 explanations. You just check it. And 300 has 4 parts. And if I am not wrong, 4 illustrations. And 5 exceptions. So I see a kind of arrangement in my mind, 3, 4, 5. I do not find it very difficult to memorize things. But there is no use for you to memorize such ideas. But I am just talking of arrangement. If you say that I can't remember everything, I will say it is not the fact that you cannot remember. Rather, the fact is you do not want to remember. You do not want to remember. What do you want to remember? You want to remember which illustration has what? I'll tell you how. I give you a very simple example just to tell you that how the subject is organized and arranged and how it can be made very interesting in your reading. Because see, if you are not interested in the subject, you will never read it carefully. And if you do not read it carefully, it will be difficult for you to memorize things. And if you do not memorize things, you may not be able to reproduce the ideas. And this is what is the difficulty in answer writing. In how this IPC is arranged. And I took analogy of body. I said, see, there is head, there is leg, so there is an arrangement. You just try to understand this. I tell you. And this is not only in the chapter, it is in the section also. अब जैसे आपको, if you say that I do not remember or memorize the definition of a particular offense, why do you want to memorize, my dear friend? Why do you want to memorize? Are you getting my idea? I propose the idea that you are not required to memorize. Think for a moment. Think for a moment, I said. Assume it. You have desire for committing theft. आपको चोरी करने की बहुत इच्छा हो रही है. Suppose करो. Did you get my idea? What will you do? Tell me. And what will you steal in this theft? Suppose karo, I am wearing a Rolex watch. And you see that this watch is Kapoor Watch Company में मैंने देखा था. ये 2.5 लाख रुपए का है. And I also want to have this. Is this clear? So now you will mentally prepare yourself first. कैसे इसको लेना है? How I can take this property from Mr. Ranjan? Are you getting my idea? Now you want to commit theft. So how will you do it? That is what Macaulay has written. I am not saying that Macaulay was a great thief and he knew the idea of committing theft. But see, this is how you can visualize the thing. मैं अपनी भाषा में लिखूंगा. It may match Macaulay's language, but the crux will remain same. Is this clear? Now you just check it in 378. You are not required to memorize. And I have not seen 378 for many days now. But it doesn't matter. How it starts? Whoever, what? Tell me. Intending. That is what I said. You had great desire. Intending for what? To take. How? Dishonestly. Because I am not going to give you. Whoever intending to take dishonestly. What? Can you commit theft of immovable property? Are you Lord Hanuman? You are not. आप भगवान हनुमान नहीं है. You can carry the whole mountain. You cannot carry the whole mountain. So what you can carry? Who are intending to take dishonestly? Any movable property, not immovable. Now see, a property which is not in your possession is not subject matter of theft. If I have thrown something in the garbage, I have abandoned my possession, I have abandoned my claim, and if you go and you pick it as garbage picker, can I question your intention? Can I blame you? The answer is, because I have abandoned my possession. I have abandoned it. So what I said, whoever intending to take dishonestly any more property out of possession of any person without the consent of that person. भाई चोरी होती है ऐसे. It will happen like this, I tell you. You will think twice, thrice, you will come to the conclusion, ऐसे ही होगा. whoever intending to take dishonestly any movable property out of possession of any person without the consent of that person moves that property. Without the consent of that person moves that property. Moves that property. I have put comma here. I am not required to memorize it. Check it. मैं नहीं देख रहा हूं कुछ भी. ये मेरे को एक दे दिया था, ये आपके काम का नहीं. मैं नहीं देख रहा हूं कुछ भी. ये क्वेश्चन लिखा हुआ है. Is this clear? So I am not looking into this. मुझे कुछ देखने की जरूरत नहीं है. Because it is all logical. Whoever, intending to take dishonestly any movable property out of possession of any person without the consent of that person, moves that property in order to such taking, is said to commit theft. Full stop. I am not required to remember. If you can understand this idea, कर लो IPC मुट्ठी में. Not only IPC, all subjects of law. All subjects of law. So, not only this, I tell you, in theft, there are 5 ingredients. There are 5 explanations, you see. There are 5 sections, you see. What I said? 5 ingredients, 5 explanations, 5 sections. These things will make your study interesting. Acha, 5 kya hai? Ingredients. This will help in mains, this will help in preliminary, this will help anywhere, in IAS, in judicial, in NET exam, in LLB exam. ये LLB exam के लिए भी relevant है. Intending to take dishonestly. 1. Any movable property out of possession of any person without the consent of that person moves that property. So there are 5 elements now. If you want to read it carefully, read it like this. Is this clear? Whoever intending to take dishonestly any movable property out of possession of any person without the consent of that person moves that property in order to such taking. This is in one part. Is said to commit theft. Is this clear? Did you understand what I said? What I said, that whenever you want to commit theft, you will start with this intention. Intention to take property. How? Dishonestly. Intending to take dishonestly. Which property? Immovable? No. Only movables. Movables. Any movable property. Out of possession of any person without the consent of and moves that. Is this clear? 5 ingredients. अब देखो, आपको जब भी सब्जेक्ट में पहले दिन आपको ट्रेन कर रहा हूं, आई एम ट्रेनिंग यू राइट नाउ एंड आई होप you will implement this idea everywhere, even in smaller subjects. Because see, idea is very important. An idea can change your life. Even Vivekananda said, what is the secret of success? What is the way to success? What is the way to success? It is not written here. I generally write it in books. Take up one idea. Take up one idea. Take up one idea. Yes, it is there in your material. Take up one idea. If you really want to become IAS, this is the lesson for you. Take up one idea. Make that one idea your life. Now, if in between it comes to your mind, I have to go to party, I have to celebrate friend's birthday, I have to go home, I have to meet different friends. This is not one idea. So many ideas are there in your mind. Take up one idea. Make that one idea your life. Think of it, dream of it, live on the idea. Let the brain, muscles, nerves, every part of your body be full of that idea. And just have every other idea. Just leave every other idea alone. Just leave it. This is the way to success. So listen to me carefully right now and adopt this idea. It will work wonderfully. I said whenever you read, you pick up the point. How can I remember 299, 300 exactly? I can remember it exactly. I am not required to make any effort. Why? Because I have that clarity of one idea there. If you do not have clarity, you will forget, you will confuse, you will be somehow not confident in the subject. Is this clear? Should I tell you 5 explanations in 5 words? You're not required to memorize everything. Why do you want to memorize everything? Is this clear? What is the first? What is the subject matter of theft? Only movable property. Till the moment property is not severed, it is not subject matter of theft. If tree is not severed, can it be subject matter of theft? This is what is illustration 1 and this is what is explanation 1. I am not required to remember. Because I have clarity of idea. We first to now decide what is the subject matter of theft, tab to chori karu. Are you getting the idea? Let us decide what is subject matter of theft. Acha, you tell me, if I have to commit theft of the tree, how can I do it? So I said in second explanation, severance is itself moving. You have severed, it is enough. And just moving, you said. What is moving? Explanation 3, 3 moving. So it is all arranged in a perfect manner. If you can pick it up, it has a rhythm. If you do not have that rhythm, the study will not be interesting. It is very interesting for me. Because I have got little bit rhythm. कभी-कभी आपने सुना होगा some singers को, and they are in different world, they are in trance, and you are sitting before them and you are lost. Why it happens? Because he has got rhythm and you could not get rhythm. So try to pick up that rhythm. There is rhythm everywhere. It is not only in music, it is in IPC also. Take that rhythm. वो rhythm पकड़ना होगा आपको. If you can catch the rhythm, it's very interesting. And that is why the name interesting penal code. So I said, what is first explanation? Movable property. Second, severance is moving. Third, 3 moving. Actual moving. Severance. And removing an obstacle. See, this is just an idea which we see generally, and that we have translated into legal provision. If I ask you a question, how can you move a thing? I can move this book by actually moving. I can move this book by actually moving. And I can, if I have to move this, what I will do? I will pick it up. This is actual. And I will not pick it up. I am keeping it here and I remove the obstacle. If I remove the obstacle, it will automatically move. So you have written that. It is common sense idea. Law is full of common sense idea. If you want to murder somebody, you will have to adopt the means, methods, measures of murdering. It is a common sense idea. So आपने कहा whoever does an act and by that he causes death, और आपने लिखा उसी को whoever causes death by doing an act. Now how can you cause death? Can you cause death by teaching? Everybody knows. I can cause death by poisoning, by shooting, by depriving him of taking essential life-saving medicines. So, just we are required to think of. Now, explanation 4. What is explanation 4? Animal. If you move the animal, you move everything with the animal. Suppose I want to steal the Naulakha Har, 9 lakh necklace worn by Tommy, Jerry. So what I will do? I will move the dog and I will move the necklace also. And last but not the least, consent can be express or implied. If I have allowed you to enter into my library and to use my book, is it not implied consent to take my book? Can I allege theft against you? The answer is no. So this was how you are required to read your subject. I can tell you many more. Now see, theft has illustration till P, I hope. And P is huh? No. I am not interested in that. I will tell you how to remember. You don't worry about that. P is 16th alphabet of English. So there are 16 illustrations. Now it's a Herculean task. How will you memorize? But this is again not difficult because you have an idea. And that idea is idea of logic, idea of intelligence, idea of experimentation, idea of expertise. If you see the first illustration there also, it says tree. If you see the second illustration, it says dog. Huh? Something like that. If you see the third illustration, it is treasure. Something like that. If you see the fourth illustration, it is servant. If you see the fifth illustration, it is entrustment. So just build an idea. A, B, C, D, E. You can develop the idea. It is not difficult, and when you write answer, and when you use these illustrations perfectly, and when you tell the examiner that see how exactly I know what is written where, will he not be happy? See, if I ask you a very simple idea, if anything is kept on my table in my office, is it in my possession or not? Tell me. Is it in my possession or not? But if I have thrown something on the road, is it in my possession? So can you see the next two illustrations? It's not difficult, I tell you. The problem is there that the students do not believe this. And they are not sincere to that extent. This is the problem. You come to me, I am here, I am telling you right now, you see. And this is not bookish knowledge, not written by Macaulay. आप कह रहे हो कौन सी किताब पढ़े? पिल्लई पढ़ लो. Has Pillai written this? Teacher is not confined to book. And if a teacher is like this, then he is not a teacher. He may be something else. And we are not sure about teacher's definition also. That's the problem. Who can be a teacher? Who can be an educator? Anybody can be an educator. One who knows how to speak English. He can be a trainer of IAS exam. Unbelievable idea. You should be such a smart person. I don't know whether I am. But you should be such a smart person that the students are interested to know, oh, ऐसा topic है, तो बड़ा अच्छा है, तो कुछ भी याद नहीं करना मुझे. आपको याद करना पड़ रहा कुछ? I remember. F, then I said A, B, C, D, E, F, G, H. First moving. I, J, K. Honor can be thief also. L. Temporary deprivation is also theft. M. FM. बहुत सुनते हो गाने. FM. Friend comes to your place, takes away your property. Does he commit theft? In that sense? FM, illustration M. And N and O. No. You can't say no to one person. And that is what is mentioned there. That is your wife. Otherwise you will lose life. And even otherwise NOW now. So you can easily remember. And no theft. Oh, yes, theft. You can remember that also. Achha, why one is theft, why other is not theft, I'll tell you later on. And last you said P, Prime Minister, MP, mistake of fact. No theft. So I'm not required to memorize anything. Why? Why I'll memorize? And if I'm asked a question of theft, let me tell you, even if I do not remember any case, even if I write this idea which is relevant in my question, I think examiner will be very happy if I explain beautifully these 5 ingredients and then I quote the relevant explanation and relevant illustration. Will you not be happy? So why he will not be happy? Are you not happy after listening to me? So why he will not be happy, tell me. But will we write this idea? Is it common idea? Is it written in books? The answer is obviously no. Is this clear? So I don't think that you will have difficulty in assimilating these 50 sections and answering those 25 questions. My job will be to answer 2 questions every day. And that is how I will answer your all questions. Is this clear? And I'll be completing syllabus like this. So now let me tell you, in the beginning here, as I have started with IPC and I have given you information how to read this IPC. Little bit I have given you information. I'll be sharing much more information later on, but Here this will suffice. Now let us go a little bit beyond this. As I said, IPC punishes the crime, the wrong. Obviously, you are going to read criminal law, so in your mind there will be certain basic questions which will come up. And first of all, question comes up, what is this crime all about? ये crime होता क्या है? And obviously, what are the constituents of crime? IPC is much concerned with this. See, let me tell you, the concept of crime depends on the criminal policy which you have. And this policy will vary according to space and time. What is crime today was not crime yesterday. What is crime here in India may not be crime there in Europe. And what is crime in USA may not be crime in India. Adultery was crime earlier in India. But is it criminal now? Tell me. No. So our policy has changed. And what is the change in policy? Just for explanation. Earlier we had an idea that in marital relation the fidelity of woman is very important, because that is the central point of having a family. But now we have moved towards individualistic institutionalization. And we are saying individual is much more important. And we are talking of equality, freedom, many more things. So what you did, you changed your policy somehow. This is one instance. There can be many changes which may be according to time necessary. We are hearing today cyber crimes. You must have heard of many frauds, many cyber theft, which were not known yesterday. But now it is very much known. And that is why you have changed provisions in IPC. If you see section 4, we have amended it. If somebody is sitting there, is targeting my computer resource here, he is committing a crime in India and he will be punished as per criminal law of India. So crime has temporal, that is according to time, and spatial, S-P-A-T-I-A-L, spatial variations. What I said? It has temporal and spatial variations. That is what I said. It has variations as per policy of a particular state. So obviously, the understanding of crime, the content of crime, the nomenclature of crime will change as per state and time. So it will change on time scale and it will change on geographical scale as well. So if anything is not definite, certain, it's difficult to describe and define it. And that is what is the problem of definition of crime. Again, you are not being asked question on why crime cannot be defined. This is university kind of question. This is what you are required to understand. You have to restrain yourself. But you must understand what is crime generally. So there is no statutory definition of crime in India also. But by referring to different definitions given by different people, different jurists, we can have understanding of crime. What can be crime? If you are asked a question, what is crime? So you will say generally, crime is a wrong which is punishable by state, for which there is punishment of imprisonment in their own way. And that is what I have given in your material also. Now see, the problem will be of memorization. So everywhere you are required to develop the technique of memorization. आपको समझना पड़ेगा. जैसे, what I have done in your material, I tell you. I have given definition of Austin, I have given definition of Kenny, I have given definition of Blackstone, and then I have written my submissions as well. And this is all based on common sense idea. Austin's definition is not an idea which we cannot remember. It's very simple. So if you see the particular page number of your material, which page number is this? 3. And I quoted 3 names before you. And what it says? What Austin says, my dear friend, what Austin says. I'll tell you how to memorize it.
A wrong which is pursued at the
A wrong which is pursued at the discretion of crown, because there was crown, here it is a state, same thing. Then it is criminal. But if it is pursued by a private party, then it is civil. See, Austin is saying very commonsensical point. You tell me, in civil dispute, who initiates action, state or you? So you are just required to keep in mind common sense. The students try to memorize things. बैठ के रटना शुरू कर देते. This is not the idea. So you will remember one word. Pursuance. Who is pursuing? Crown, crime. Private person, civil. So I remember Austin's definition. If a wrong is being pursued by or can be only pursued by crown or state, then it is criminal. And if it is remissible, it is remissible by crown alone. As he is the pursuer, he can only remit. So if a wrong is pursued at the discretion of a state, and it is remissible by crown or state alone, then it is criminal. Then it is criminal. But if it can be pursued by a private party, and if it can be compromised, exonerated, remitted by private party, in civil law you can compromise any time, then it is you write the same idea in your own language. You are not required to memorize. You are not preparing for preliminary examination. Exact words are not required. So just remember the idea and produce idea in your own words. So mains examination is a little easier in that sense. You pick up the idea, you make synopsis. Now what Kenny says? Kenny says, if the wrong whose sanction is punitive, then it is criminal. And if the sanction is not punitive, it is compensatory, it is civil. I am adding my own words, compensatory. Achha, why in criminal law sanction is punitive always or generally? The reason is what obvious. Because I am a state subject and the state has given me guarantee that they will protect my body, they will protect my property, they will protect my reputation. So if anybody interferes with my bodily interests, my property interests, my reputation interests, whose authority is being challenged? The states. So how a state can maintain its might? A state can maintain its might only by punitive action. Only by punitive action. It is not easy to maintain. And that is why it is necessary that there should be penal action. Sometimes we feel bad about it, but this is must to maintain society. This is must to maintain an order. Is this clear? But on the other hand, when the sanction is not punitive, it is just compensatory, it is not criminal, it is civil. So what is the word here? Sanction. Punitive or compensatory. आपको कुछ नहीं करना. You are not required to make much effort. Just pick up the idea and explain that idea in your own words. So Austin, pursuance, remission. Kenny, sanction. Then what Blackstone said? Blackstone said that criminal wrongs are violations of public rights and duties. Where you are challenging the whole public authority. You have a duty as being member of the society, and I have a right as a member of society. As I am the subject of a state, the state has given me certain rights. A state has promised me that my body, my property will be protected. And if anybody interferes with my interest, they will be punished, penalized. So the person who are going to commit the crime, they are under duties. And I have got rights. So what is basically criminal wrong? So he says it is violation of public rights and duties. My public right is violated and you are doing wrong against your public duty. And there are many people who have defined crime in different words. Somebody said criminal wrongs are worthy of serious condemnation. So different jurists have defined crime in their own words. But now, after reading these 3-4 definitions, you must have realized what is the nature and character of criminal wrong. So you can give your own definition also. If I am asked what is the definition of crime, I will say criminal wrongs are those wrongs which are pursued by state authorities, because in India we do not have crown. And if it can be remitted, it can be remitted by state alone, and for which there is a punitive action which will be taken by the state, and obviously it is worthy of serious condemnation also. What I have done? I have mixed all three. So Austin, Kenny, Blackstone. A, B, K. I defined crime. So idea is very simple. It's not a great thing. It's just question of application. You read the idea, you apply the idea, and keep the idea in mind. We are not required to go into nitty-gritties of everything. That is not expected of you. Men's examination, we do not expect who said exactly what. Are they going to ask you what Austin said exactly? Are they going to ask you what Blackstone said exactly? Are they going to ask you what Kenny said? This can be a question in preliminary. But can it be in mains? So your task is very simpler. You just realize this idea. It's very simple. So you are involved in, sir, yaad hi nahi hota, what Austin said, what Kenny said, what Blackstone. Who says that you remember it? Who said it? I never said it. You remember me and my idea, that's all. I never said you remember those things. Is this clear? Now you are asked further question. What are the constituents of a crime? So, it's very important for your understanding that you should understand it. I give you a very simple clarification that you are not required to look into 6 ingredients, 7 ingredients, 5, nothing like that. You just think, you just keep in mind that there are 2 key constituents of crime, mens rea and nothing else. Mens rea is all mental part and actus reus is all physical part. In all crime, you first mentally plan, contemplate. Like if I have to commit theft of a particular diamond, I will mentally prepare myself first. I'll plan. And then physically I will execute this plan. So in crime, basically there are 2 key constituents, mens rea and actus reus. And that is why we say actus non facit reum nisi mens sit rea. This is what is very simple. Actus non facit reum nisi mens sit rea. Act alone does not constitute crime unless and until supported by guilty mind. So very simple. Act alone does not constitute crime unless and until supported by guilty mind. Now in all crime you will find almost that these 2 ingredients are there. Now even in common law, in England, we adopted this formula that there can be no crime without mens rea. So this is a general rule. You read cases of Seras versus Deerachon, Brand versus Wood, and many other cases of English criminal law. You will find that they have consistently taken this position that all crimes must have mens rea. And there is justification for it, I tell you. If you want to understand, I can go in little bit explanation. Suppose I happen to hit you in a bus, but unintentionally, because there was jerk and I have happened to hit you and you were a little bit injured. Even then, will you mind it much? I will say sorry and again, and perhaps you will exonerate me, excuse me, forgive me. But suppose, on the other hand, I deliberately hit you. I intentionally go towards you with threatening gesture and I use force against you. Now you are hit, you are hurt. Will you mind it or not? The answer is yes. What is the difference between the 2? In first, no intention. In second, so this second element, that is mens rea, is the justification behind punishment. I will be punished when I have done some wrong intentionally. If I kill somebody accidentally, perhaps I'll get benefit of some exception. But if I kill somebody intentionally, will law excuse me? Will I get any defense? The answer is no. The difference is quite obvious. The first situation, it was devoid of any kind of guilty mind. Second situation, it is supported by guilty mind. So guilty mind or intention is the reason or justification for punishment. And this is again, I must tell you, a common sense idea. See how law develops. It develops with common sense idea. If you want to frame a statute, I must tell you, you should have common sense of that particular thing which you are going to draft. You just acquaint with common problems and you find common solutions. Obviously, you should look to that problem and solution with different angles. And you can formulate a law, I tell you. If you have not done it till date, if you find opportunity, do it and you will succeed. This is how we have drafted IPC. Macaulay did not have any dream. He drafted it by common sense. He drafted this IPC beautifully. He had all common sense. So what I said, mens rea is justification behind punishment. And in criminal wrongs you want to give punishment. Can he say it is punitive? So if I want to punish, I must have justification for punishment. And that is the justification that it has been done intentionally, knowingly, deliberately. And there can be different sets of mens rea. We'll read about that. In IPC, you will find that there are different sets of mens rea. Rashly, negligently, wantonly. Many things. Malignantly. Intentionally, knowingly. Having reason to believe. So many sets of mens rea. In different situations, we have different mens rea. So I said in English criminal law also, mens rea was a necessary ingredient because it is justification for crime. In Indian law, mens rea has been adopted in criminal law in different ways. Positively, negatively. Positively, now you take any example. If I have to write this question, I can give many examples. I'll take any offense. I'll say, see, I give you a very simple example. Murder. And attempt to commit murder. So this is 307, this is 302. Is this clear? Just try to understand what I am saying. If you see this 302, 307, you find that mens rea in both cases is same. If you have read 307. Who causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, 299. Or with the knowledge that by such act he is likely to cause death. And then 300 we read, we said culpable homicide is murder. And then many things are written. So intention is to cause death. In this case also, if I take now the first one, intention to cause, here also intention to cause death. This will explain you other thing also. Intention is same. I'll be explaining 2 points here. I am explaining the fact that mens rea and actus reus constitute a crime, and I am explaining also what is actus reus. Now, in this case, intention to cause death, death occurs. So it is called murder under section. Here, death does not occur. So it is called, in that sense. Is this clear? Tell me yes or no. Now, what is the difference between these two situations? Mens rea is same, actus reus is different. But you must notice one thing in between, and that is in both cases he has fired. Same gunshot. So act is same in both. But in one case he is saved, in another case he is dead. A fires a gunshot against B and it hits B on his head. B dies then and there. Case is covered in. A fires a gunshot on B. But B is wearing Billa number 786. And it does not cause his death. He is saved. Are you getting the point? I have done the same act. I fired towards your chest. In first case you died. Let us forget head. I fired on chest. A fires on B, vital part of body, chest. And it hits B on chest and B dies. But again A fires on C, but C is wearing Billa number 786. So, it does not cause his death and C is not dead. So what is this? You have done the same act, firing on the chest of your victim. But in one case, one is dead, another is not dead. So what is the difference in the two situations? In one case, actus reus is death. In another case, that actus reus of death is not occurring. So the offenses are different, though mens rea is same. And it also explains the fact that actus reus is not firing of the gunshot. It is basically the consequence of your act. So this is what Kenny said. Mens rea, do we understand? Guilty mind. But what is actus reus? Actus reus is not the activity. It is the event. You mind words what I said. Actus reus is not the activity. It is the event. Actus reus is not the conduct. It is the consequence. Actus reus is not the conduct, it is consequence. Now, if I ask you a question, what is the difference between 299, 300? You will say in both cases death occurs, actus reus is same. So what is the difference? Mens rea is different. If I ask you a question, what is difference between 379 and 380? In 379 it is simple theft. Somebody picks money from your pocket, it is simple theft. And somebody goes to your house and commits theft, it is theft from dwelling house. What is the difference between the two situations? Mens rea is same, actus reus is different, physical part is different. In one case, he has taken money from your pocket. In another case, he has gone to your home and he has taken money from there. So, whenever you are asked a question on difference-based areas, like you will be asked a question, what is the difference between culpable homicide and murder? What is the difference between theft and CBT? What is the difference between cheating and CBT? You just explain that question on the basis of mens rea and actus reus. Is this clear? So I have given you a little bit guideline also. But let me come to the point. I was discussing the idea of mens rea. So what is mens rea? Mens rea is guilty mind. It is that mental contemplation or element which is prohibited by law. If I have intention to cause death of somebody, it is wrong. It is wrong. But then can we punish mens rea? The answer is no. Why? Because how will you know the mens rea of a person? Unless and until he expresses that mens rea. Unless and until that mens rea is manifested. Can you know it? The answer is no. The answer is no. I can know mens rea only if it is manifested. So it is necessary that actus reus must be there to punish a crime. And crime can never constitute of mens rea alone. So in every crime there will be mens rea as well as actus reus. You pick any crime. Be it theft, be it murder, be it attempt to murder. There can be certain exception to this rule which we'll discuss later on. So this fact is clear. In Indian law, mens rea is a necessary ingredient of every crime and every offence generally prescribes element of mens rea. Is this clear? Is this all right? Now, IPC also have mens rea in different way. This was positive, number one. That see, murder has mens rea of intention to cause death, intention to cause bodily injury, knowledge that by such act he is likely to cause death. These are mens rea. Is this clear? But IPC also talks of mens rea negatively. How? It says that if there is no mens rea, there can be no crime. The whole chapter 4 of IPC, that is general exception. These are different situations of no mens rea. As mens rea is not there, so crime cannot be there. No mens rea, no crime. If I am bound by law to do something, can I be punished? If I am adhering to the direction of law, can I be punished? The answer is no. The answer is no. Section 76, 78, 79, whatever you read. 80 accident, 81 necessity, 82 infancy, 83 maturity, 84 insanity, 85 intoxication, whatever you read, 87 consent, 88 operation by surgeon, etc., 89 is guardianship. One word, you can remember anything, I remember everything. 92 benevolence. You see, check it, it is there. It is there. 93 communication, 94 threat, 95 trivials, 96 right of private defense. So in all this situation, is there any mens rea? If I am defending myself against some aggressor, am I committing the crime with wrong intention? Tell me. I have no wrong intention. 94 threat or duress. If somebody is threatening me to do something wrong, is it my violence? I am doing it voluntarily. The answer is no. So should I be punished? The answer is no. But then there are ifs and buts, I'll tell you. So what I said, that mens rea is there in IPC positively as well as negatively. So if you are asked a question, whether this IPC contains the idea of actus non facit reum nisi mens rea, yes, it has. It also has the idea of mens rea and actus reus, and no crime can be committed without mens rea. But then there are ifs and buts. I'll explain it little further tomorrow. Thank you very much.